Welcome back to Saturday Agenda. I'm Kelmany Dukart. Ketanji Brown Jackson officially sworn in to the U.S. Supreme Court, taking her oath. This while the court is set to begin hearing two major cases on this week when the court goes into session on Monday. For more on this, we're joined by former prosecutor and constitutional law attorney and Newsmax contributor Amir Benno and distinguished university professor at Touro University, Thane Rosenbaum. Want to correct something in our intro there, that she was already previously sworn in. She's already been working on the court. There was a ceremony at the Supreme Court yesterday with U.S. President Joe Biden and Vice President Kamala Harris. Gentlemen, this is really interesting as the Supreme Court session kicks into high gear. We have two major cases coming up, but I want to just quickly start, Thane, with you. We know Ketanji Brown Jackson doesn't actually change the makeup of the court, but she could have a profound impact and influence on the cases that the court considers this term.
She could very well, Kelmany, become sort of the leader of the liberal bloc. Remember, Clarence Thomas was never embraced by African Americans in this country. And I suspect that Ketanji Brown Jackson is going to be treated like Ruth Bader Ginsburg. She's going to have a rock star status, certainly among the progressive left. It is a shame that Clarence Thomas was, virtually ignored by people of his own race. But I think she's going to have a very profound effect on the court, and I think she's going to have an outspoken effect on the court. And let me just say, she was a federal public defender. She comes from a very different background. Very interested in sentencing guidelines, prison reform. Remember, Kelmany, we're living in an era of cashless bail and increased crime, and she might take a position that's much more woke and much more progressive and in some ways regressive at a time where crime is spiking. It's going to be interesting to see what the Supreme Court says about the rights of states to protect its citizens from criminals.
Yeah, and Amir, I want to talk about a couple of the cases that are coming up right now. One of them is Milligan versus Merrell. The ACLU says that this is a case that could determine the future of voting rights in America. Talk to us a little bit about what we may hear in oral arguments.
Right. So great to be here with both of you. It's always a pleasure to be with Thane. And I agree with what he said before. 100% about Ketanji Brown Jackson. Getting to the Merrell case, that is a Voting Rights Act case, Section 2, which says that you can't discriminate on the basis of race in elections. And essentially what happened in that case is Alabama drew its lines for congressional elections, and they were challenged, saying that there was only, out of 7 different congressional districts, only one of them was majority minority, meaning that they said that they put all the African Americans into one district. And so they challenged it on the Voting Rights Act. And the state saying, well, listen, there are other reasons why these lines were drawn the way they were. There's geographic regions. We don't want to break apart cities. There's topography, where's, mountains and things like that we have to draw the lines, taking those into account. And so if we only are focused on race, and that's the sine qua non, the one thing that matters, doesn't that violate the Equal Protection Clause? And that is what the Supreme Court is going to have to decide here. What are the guidelines for determining whether a Voting Rights Act is violated? And how does it square with the prescriptions of the U.S. Constitution? Really important case, because up till now, the Voting Rights Act has been it's been a mess in terms of the legal decisions that have come out in terms of giving guidance to the states. So hopefully the states will get some clear direction on which way to go.
Thane, I want to get your thoughts as well.
Well, there's the Alabama case and there's also the North Carolina case. So there's 2 cases coming up dealing with elections. And the reason North Carolina is interesting is because in that issue about redrawing the voting districts, the question then becomes what happens to Article 1, Section 4 of the Constitution, which is called the Elections Clause. In both of these cases, in Alabama and North Carolina, state legislatures created new districts and new laws, and the courts, either a federal court in Alabama and a state court in North Carolina, invalidated those changes. But the Constitution says, Kelmany, and certainly Amir knows this because he's a constitutional scholar, And I'm very happy to be always partnered with Amir on Kilmeny's show. I want to make that clear. But what's interesting about the North Carolina case is that it invokes something, frankly, that harkens back to the last election, which is called the Elections Clause, Article 1, Section 4, which says, when it comes to federal elections, state legislatures set the time, place, and manner for the rules. And what that means is not independent, not courts, not state courts, not federal courts, and not state election officials. And so that's what you have here. You're going to see here for the first time the Supreme Court taking a look at how much authority does the Election Clause have? Because if it does, it means that the rules for federal elections are always established by legislatures and not by courts and not by election officials. Why is this important? Because in the last election, and I said this on Newsmax the very morning after, this was, I thought, the strong constitutional argument about the election, which was rules were changed across the country, but not by state legislatures, mostly by courts and independent state election officials. So there was a constitutional defect there. There was an infirmity, which I hope Amir will speak to, too. It's very, very important, Kilmeny, to think that we've never really discussed this issue. Yes, there was a pandemic. Yes, the pandemic caused emergency circumstances, which had caused people to act. But technically, our founding fathers said rules for federal elections are established by state legislatures alone. And the change that was made by other unelected officials may have been constitutionally defective, and that's what the court's going to be looking at in North Carolina.
Amir, I'm told we're out of time, but I want to just give you a quick moment. Any final thoughts?
No, he's 100% right. It's to what extent can a state court invalidate what the state legislature did? U.S. Congress, the Constitution says it's state legislatures have to make those rules, not the state legislatures. So because it says that clearly, the text does, then they're the ones who have to make that decision. And the court's going to have to decide to what extent then can a state court invalidate a state law when the U.S. Constitution says that it's up to the state legislature. Really interesting legal question.
Gentlemen, we'll be keeping a close eye on both of those cases. Amir Benno, Thane Rosenbaum, always great to have you here. Thank you.
Thank you.
Thank you.